So hello, welcome to the United Nations Legal Identity Agenda webinar series. My name is Risa Arai. I am a UNDP Global Focal Point of Legal Identity, leading policy development and country support, and I am also a lead coordinator of the UN Legal Identity Agenda Task Force. And I have the honor of facilitating today's UN LIA webinar on data protection and privacy. So normally this webinar series is targeted for UNCT staff, but since today's topic is extremely important, we decided to make it public. And I'd like to once again welcome all. So today's webinar has three objectives. One is to officially launch the data protection and privacy guide that UNDP recently launched. And we have an author of this guide from the Center for Communication Governance, National Law University, Delhi. Second objective is to do knowledge exchange on the data protection and privacy-related activities across development communities. And the third is to hear from non-UN voices how we can do better. For that purpose, we have 5 speakers today. Jalak and Aishwara from National Law University, Delhi, Center for Communication Governance, who are the author of our guide on data protection and privacy, as I mentioned. Azhar from UNGP Malawi, Joanne from UNGP Kenya, and Pam from World Privacy Forum. Jalaken and Aishwara shall make a presentation on the content of the guides. Azhar and then Joanne shall present UNDP's work around data protection and privacy, especially when we work in the area of legal identity. And Pam shall make constructive recommendations on how UN can strengthen our work around data protection and privacy. I actually need to do special thanks to Joanne because we originally had a speaker from Honduras and then she had a medical emergency. So Joanne decided to come in at the very last minute. So thank you so much, Joanne. So without further ado, I'd like to start the first official segment of this webinar. So Jalaken and Aishwara, please, floor is yours.
Thank you so much, Risa. I'm very glad to be at this webinar today and share insights and findings from the report that the Center for Communication Governance at the National Law University, Delhi did in collaboration with UNDP. So just to set some context on the report, this report really aims to provide UN member states with suggested guidance on how to develop robust national level data protection legislation. And this report has been drafted in the context and background of Target 16.9 of the Sustainable Development Goals, which aims to provide legal identity for all, whether it's birth registration or death registration, death certificates. And the reason that creating this kind of foundational identity document is really necessary is because it really enables an individual to be recognized as a person before the law, enables them to exercise various legal rights, and it really allows them to fully participate in, their society, social, political, and economic systems. And of course, now operationalizing and implementing such a legal ID system necessitates the collection of huge amounts and collection and processing of large amounts of personal data of individuals. And given that privacy is really recognized as a fundamental and a very, very crucial fundamental human right around the world, that begs the question of how are we going to adequately protect the privacy of these individuals who are sharing very sensitive and personal data about themselves with the state in order to operationalize this goal of legal identity for all. And this becomes even more relevant because recently we've seen that governments have really started to expand the use of digital technologies in identity management systems. And this in turn has beneficial impacts in terms of governments being more effectively able to deliver public and welfare services, while of course raising its own swath of challenges. And particularly over the last few years during the COVID-19 pandemic, we saw the increasing reliance of states on various technologies, whether it's contact tracing or vaccine sort of digital mechanisms. And all of these technologies played a key role in the way states were seeking to address and manage the challenges of the pandemic within their country contexts. And this also brought forth many questions around the privacy risks with data collection by states. So given this background and this context, and also the increasing sharing of data across state boundaries, we really felt, that it's important for us to talk about and really study what framing an effective data protection legislation could look like. And we really hope that all of you who are, at the webinar today will go through this report, will share it widely, so that it serves as a baseline document for people to learn from as they are figuring out either, creating data protection legislation or, further enhancing existing data protection legislation or policy frameworks they currently have. I just wanted to give you now on the next slide, just talk you through some of the methodology elements to give you a sense of what it was that was involved in putting this report together. So, Risa very kindly introduced Aishwarya and me as authors on the report, but actually if you open the link to the report, you'll see that there are multiple and dozens of authors on this report, and it really was a mega exercise, a team of people really coming together over a 2-year period to put all of this information and analysis together for you. And we've drafted this report thematically, and it covers various elements in a typical data protection framework. And my colleague Aishwarya will take you through some of the key insights across these various themes that we've been able to glean from our research. And it's really a comparative analysis of various regional frameworks across the EU, Africa, ASEAN, Caribbean, South America. And the idea was that this regional diversity would really allow us to assess how data protection frameworks are developing across the world. What really are the best practices and common practices we are seeing emerge globally? What are differences? What are similarities? What can we learn from what different regions across the world are really adopting? And besides this sort of regional framework analysis, we also, undertook to understand the way national laws are developing, various programs are developing, significant case law that impacts the thinking around privacy data protection in the context of legal ID systems. And we also drew tremendously on, contemporary academic research and policy analysis that is available in the public domain. And this really helped us draw together the various strands and approaches that are developing to be able to provide our readers with the most comprehensive picture of approaches and challenges that they may see as they draft data protection legislation. Now, the report is primarily written from given that the report is primarily written from the perspective of data protection in the context of legal ID systems, we've tried to streamline our focus perhaps more around government collection of data, and rather than getting into the processing and collection of data by private actors. But many of the themes and the chapters and the insights there would equally apply in the context of a country developing a data protection legislation that they're seeking to apply to both government actors as well as private actors. So while, the focus in our report is more on, government systems and data protection related to that, much of the report would apply equally in the context of private sector use of data. So before I hand over to my colleague Aishwarya, who will take you through some of the key insights and an overview of the report, I did want to very quickly tell you about the Center for Communication Governance at the National Law University, Delhi. I'm the executive director at CCG. My colleague Aishwarya is the project manager and really took the lead on developing this report. And CCG is the only academic center in India dedicated to researching and studying information technology, law, and policy. And we work on areas ranging from privacy and data protection to data governance, platform governance, social media regulation, governance of emerging technologies like AI, blockchain, as well as cybersecurity. And our idea is to really contribute to the advancement of human rights, rule of law, good governance, and ensure effective policy making, not only in India, but across the global majority. And to do this, we undertake academic research, provide policy input domestically as well as internationally, and facilitate the capacity building of stakeholders at both the domestic and international level. One of the interesting projects that's sort of related to the theme of our discussion today that I wanted to highlight to you is the Privacy Law Library that we've developed over the last few years, which is a global database that tracks and summarizes significant privacy jurisprudence emerging in courts across the world. We currently have 200 plus cases from 15 plus jurisdictions, and these range from South Korea to Japan to Singapore, to Kenya, to the Inter-American Court of Human Rights, to the US, and EU, India, Pakistan, Sri Lanka. So it's got a really great mix of countries, and I'd encourage you to check it out. I'll drop a link in the chat. With this, I want to hand over to my colleague Aishwarya, who will take us through some of the key insights and themes from our report. However, time is short, so there's only so much we can share with you. But I would encourage you to go through the report. We have an excellent executive summary right at the beginning, which will give you a very quick overview of the report. And then you can, of course, choose to explore particular sections that are particularly relevant to the work or thinking that you are doing. Thank you so much. And I really want to thank Nahil and Risa for all the support they extended us in developing and putting this report together.
Thanks so much, Jhalak. So for a broad context, we covered 9 chapters in this report, but today we're going to be talking about 5 key chapters because, again, the report is massive. We don't have time to get into all of it. So we're going to be covering these: the background and context of privacy and data protection, the key principles, key rights that we provide data set. Most of these frameworks envisage. The next slide, please. So in terms of the background and context of the report itself, so we have an introductory chapter that sort of sets out the background of privacy and data protection. So how it has evolved over time, how it has evolved to have national and international recognition as a core human right. And so here we cover, for example, the different international instruments and the national laws that provide for privacy. But we also highlight the work that the UN has done in contributing to the development of this field. So we also have a section in this chapter on how privacy and data protection are important to exercising all other rights and freedoms. So there are different aspects of privacy. So depending on whether you're talking about bodily privacy or decisional privacy or communications privacy, for example, it will implicate all other sort of rights and freedoms. So this is the kind of context that we put in place for the report itself. So we cover these key data protection, so these are the key data protection principles that we've seen coming up through looking at the 11 frameworks that we've identified. So the data protection principles are the core aspects of how privacy is generally operationalized through law. And so this leads both to obligations as well as the rights that you will see in these frameworks. So like Jhalak mentioned, we have written the report from the perspective of states, but they're also equally applicable to private entities. So this is a broad overview of the principles. So fairness and lawfulness essentially is just that the idea that whoever processes information, so the controller, does so in a way that's backed by law and in ways that you can reasonably expect, so that the data subject or the individual has an idea of who this relates to, how their data is going to be processed. Notice and consent is one of the most important frameworks that principles that we see across frameworks. And it's also central to how we think of data protection today as privacy self-management, or how the fact that you control how information about you is managed and who it's disclosed to. There are different issues that are coming up with the concept of consent, which we have highlighted in the report as well. So again, purpose limitation is something that you find across all frameworks. The idea is just that the data subject knows what information is provided for, so that they're able to provide the kind of consent that is meaningful that we just spoke about before. We also have data minimization showing up in different frameworks as a core principle to make sure that only the amount of information that you need for whatever purpose you're collecting it is collected, so that you're not creating a honeypot of or a large database that can be vulnerable to hacking, but you're also preventing discriminatory outcomes down the line based on protected information. So the last two, so the integrity, confidentiality, and availability just deal with the security of the information, making sure that it is inaccessible unless necessary, and that it's also kept updated. Transparency and accountability takes up a whole chapter in our report because it's one of the most important principles, and it ties to all of the other principles that we've spoken about in different ways. So this just essentially is meant to provide relevant information to data subjects, and also to encourage fostering trust in the data subjects. So this is done in different ways, including privacy by design, conducting data protection impact assessments, reporting breaches, etc. But we see different combinations of these across different frameworks. We're also going to just talk briefly about the different rights that we've seen coming up across these different frameworks. So again, not all of the frameworks provide for all of these rights, but at least the right to access and confirmation and rectification and erasure and deletion are common across the frameworks, because these are the most foundational sort of rights to provide to a data subject. Essentially, access and confirmation just is the first step for anything, because unless you know what kind of information is being processed about you, it's very hard to take any kind of decisions thereafter based on it. And rectification and erasure deletions. So this right to erasure is not the same as the right to be forgotten, which we'll cover after, but essentially just that you can correct the information that you have provided to a controller in case something has changed on your behalf, or if they have inaccurate information. And this becomes especially important in the context of state processing, because you don't want inaccurate information to be the reason that someone's not able to access public services or have inaccurate decisions made on their behalf. So the next is the famous or infamous right to be forgotten, depending on how you see it. So this is provided under the GDPR, and it's a very specific right, which is also broader than what I just spoke about, and is primarily, you will see, exercised in the context of the internet. The right to objection, restrict processing, are basically just different ways and extents to which a data subject can make sure that the controller stops processing that information for specific purposes. Again, it's hard to sort of summarize this in like limited time, but our report has a lot of information on this as well. So the data portability right is only available under the GDPR, and this is primarily meant to foster interoperability and competition in the markets, and so isn't as, although it is also useful for state processing, it's more relevant for private processing. And the right against automated decision making, so you see that in the GDPR, you see that in Convention 108 and in the African Union Convention, which is essentially the right not to be subject to a decision based on a purely automatic process. And so you have the right to be able to make your own representations and challenge the decisions arrived through these. Very quickly, all data protection frameworks that we've seen across the world provide for some exemptions to states. These are typically for certain specified purposes. So usually you would see national security, investigation of crimes, performing regulatory functions, and some broader exemptions, like sometimes you see public order, for example. But all of this has to be subject to international safeguards in the context of what is applicable when there's a restriction on the right to privacy. So usually they are the four that you see in front of you, which is that the restrictions must be provided by law, must not be arbitrary. So it needs to be clear to the person who is reading the law that this is in the circumstances in which they'll be applied. They must pursue a legitimate aim, which again has a specific meaning, and also be necessary and proportional to achieving these aims. So you're not collecting more information, restricting the right, more than it is necessary. So this is the last aspect of the report that we'll be talking about today, which is just the regulatory structure that needs to exist to actually operationalize these frameworks. So the extent of detail that is provided differs substantially across the framework. So you see that it's most detailed in the GDPR, Convention 108, the Australian Union Convention, and the HIPCAR privacy framework. You also have actually a lot of detail in the Commonwealth privacy bills as well. Just the need for covering this in frameworks and why this is important is because there's only enforcement if you have an effective regulator. And since it's a relatively new area, we do need to build expertise and make sure that that's provided for through adequate funding and resources and adequate autonomy in the regulator as well. So when we talk about independence and transparency and accountability, these are key parts of regulatory design, especially in a situation. Independence becomes especially important in a situation where you are regulating the state, which is one of the largest collectors and processors of data, and especially in the context of a data protection regulator, which regulates both states and private entities. So it needs to be able to take decisions fairly across these sectors. And transparency and accountability is just meant to offset and sort of hold these two in tension, which is just that independent functioning obviously doesn't mean no monitoring. And so how you hold the regulator themselves accountable through measures like regulatory reviews and reporting requirements. So this is broadly an overview of these key chapters that we've covered in the report. Thank you so much. That's it from us, Risa.
Thank you so much, Aishwarya and Jalak, for the comprehensive but concise presentation. I pasted the link to the guide and also the resources of the CCG in the chat. So hope everyone can see it, but if not, I'm gonna send you another email after the webinar. So next I shall move to the introduction, the recent UNGP work on data protection and privacy. So first we shall have Azhar from UNGP Malawi. UNGP Malawi has our flagship national ID project. And as a part of it, the country office supported the government on data protection and privacy. So Azhar, over to you, and then I am showing your slide just right now.
Yeah, thank you. Thank you, Risa. Thank you, colleagues. I will try to stick to the time. Obviously, you know, the work that UNDP has been doing in Malawi it's quite historical because it was started back in 2016. So let me take you on the legal framework, the overview of the legal framework. So the current National Registration Act was passed in 2010. So you can imagine that, you know, we are working in a legal environment currently, which is very much outdated. And the National Registration Bureau is one of the is the mandated institution, is the policy holder for the ID and civil registration. And even the regulations that came into force were in 2015. And there is one law that is related to the electronic transactions and cybersecurity, which has a very small component related to the data protection and privacy part that again is quite outdated. So the current environment in which we are working was based on basically physical forms and registers. So everything that is there in the law with regard to the national ID and civil registration, it doesn't talk about any digitization. So no digitization is reflected in the current law, and it talks about forms, physical registers, and that kind of information. Currently, there's a process of a legal review that is being undertaken, and obviously there is a set of consultations that are happening right now, and we are looking into the different elements around, you know, the definitions around the data privacy, around biometric data, the data of the individuals, the digital credentials, data security and data sharing protocols. So but it is a work in progress. And then there is one more draft law that I will delve a bit more detailed on, which was supported by the World Bank, and that is on the Data Protection Bill of 2021. So this project currently it's started back in 2016. And it has laid actually the foundation for the national ID, and also started working on civil registration since last year extensively. So these two elements on the national ID and civil registration from the UNDP support on CRVS are being looked as critical components of the digital public infrastructure, because here it is seen as the founding elements on which the whole digital public infrastructure space that consists of a digital ID, digital identification, the digital payments, and also the digital data sharing to be built on this platform. So it is an important subset for the digital public infrastructure. So on the national ID, the national ID is one of the most extensively circulated one currently. So all the adults, pretty much around 10.3 million, which are in Malawi, they have the IDs with the biometric data. And there is an e-payment P2G payment service, which is also available on the digital ID for people to make payments. We are coming up now with the concept of a further enhancement on a fully digital ID solution that can be available on smartphone and with digitally signed QR codes. And there have been various updates on the software that has been undertaken by UNDP. So that is becoming the foundation of this whole exercise right now. On the births, basically, it's the work was started last year in terms of births being registered in the hospitals and also in the communities as well. So 1.5 million births have been registered in 3 districts. It was rolled out, but this is currently work in progress. Death registration is very complicated. Currently, there are very few deaths that have been registered, as majority of the deaths happen in the community. Again, a pilot initiative is currently happening as we speak right now. And on marriage registration, the portfolio rested with the Registrar General, and there has been a new amendment that has been done. And National Registration Bureau is also going to be has been mandated to undertake and take it as a lead. In terms of the country, like, in terms of the national registration, you would see that pretty much most of the districts have been covered. There were different phases of the registration that happened. And currently there are 10.3 million registrants. So Malawi actually got a recognition from the World Summit on the Information Technology and was one of the 5 contestants that won an award. So it is quite a recognized project globally. So this is just to give you a brief outlay that, we are currently working on a fully digital ID solution. So this also why I wanted to touch base a bit is because this brings in fundamentally a bit of more challenges as well with regard to the data protection and data privacy, but also provides an opportunity in terms of control of the data. So it's the concept of self-sovereignty and a decentralized ID processes and biometric verification processes enable people to have more control over the data. So obviously you have these legal elements and legal parameters, but in the same way, it is important to have some of these technological solutions also to provide individuals the right and control over data, but so that they are able to share with whatever institution, like if it is the bank or a government agency they want to share their data with, so they are actually agreeing to that data, and they are the one who are controlling that data, so that data is not just sitting in a government institution, which the government institution is there at. So the individual is not at the whims and wishes of the government institution. So now looking at this data protection bill, which is currently being, I think it is still in the Ministry of Justice. It is still not gone to the Parliament. I will come in the end to some of those challenges, why it's still being debated and discussed. But just to look at some of the key features of the current bill. So this bill was supported through an initiative of the World Bank, and after consultations starting in 2019 and 20, this bill came up as a draft bill in 2021. So it has all those key definitions that are important in terms of defining what personal data is, what data breach is, what constitutes sensitive data, what are the duties and functions of the authority which will be responsible for implementing the law. In the case of Malawi, it's the Malawi Communication and Regulatory Authority, MECRA, which is responsible, which has been proposed as the responsible entity in terms of the functions. Then it's an important role of the Malawi Human Rights Commission has also been embedded in the law, and the authority will have to consult with the Malawi Human Rights Commission as more details, including the regulations, are developed in line with the law. Then the use of the personal data is identified across different sectors. So what it does is that it basically says that the sectors of the economy and the society as well. So for example, health, education, financial services, employment, commerce, digital identification, plus scientific research. So it lists down a number of areas and the other areas that might be prescribed by the authority. So that is something which has been laid out there. Then it talks about good practices and codes of conduct. It briefly lays out pretty much the same principles that our colleagues were also indicating, but obviously the details had to be part of some codes of conduct that will have to be enacted by the authority. Then it has certain principles around which principles of data, personal data, and it talks about lawfulness of the data processing, that how to make the process of the data processing in line with the framework of the different institutions. So it clearly lays down each and every type of data that personal data that can be captured under the different legal frameworks which are there in Malawi. Then the processing of the data is also is a key element that is provided in the law, and it talks about in both aspects, it talks about the consent of the individual is very critical in both of them. So the first thing that comes is that the data is subject to that the consent has not been withdrawn for the purposes of the processing. So the consent becomes an important part of all these elements in terms of the data protection law. Then where there are kind of risks associated, high risk with regards to the rights and freedom of a data subject, then the law provides that the entity that is responsible for undertaking that data collection and processing needs to do a data protection impact assessment and will have to be submitted to the authority for approval before they proceed in terms of any data collection exercise. Then it provides for the obligations of the data collector, that the data collector, which primarily it defines as the government organizations in terms of to ensure security, integrity, confidentiality of the personal information in line with the different parts of the law. Then there is elements related to the rights of the individual, of the data subject. So the rights are also very clearly categorized. So I was looking at the presentation just before me, and in fact, the right in terms of the first is the right of collection of the information, which is the consent, consent given by the individual. That is there, that is explained in detail. Then withdrawal of the consent is also there. Right to objection has also been clearly indicated that a person, if it infringes on the rights and it is a substantial distress to the person, and it can cause unwarranted damage, then the person can have a right to object in terms of those grounds. Automated decision making is also one of the key elements, and the data portability has also been provided for as part of the rights of the data subject. So it is quite comprehensive as far as the rights of the data subject go. Then in terms of data security and data breaches, it provides for the entire procedure in terms of the measures that needs to be taken to avoid such breaches. If a breach happens, what are the steps that needs to be taken in terms of notification, who responds to it, how does an investigation happens, and then it has the penalties that go with any kind of breach of data security that has occurred. Then it also provides some broad principles around cross-border transfer of personal data. Yes, I will be on track. So on these elements. So the cross-border element has also been put in the law. Next, please. So in terms of things which are currently not very clear are anonymization and pseudonymization in terms of the law, where you are talking about basically anonymizing like encryption of the personal information and the data, and the pseudonyms that you use try to protecting the individual's identities. Ethical considerations, there should have been some reflection which is not there. Then blockchain and AI is also currently not part of it, and the use of the data by the private sector. So it talks about the private entities, the data processors, but it does not differentiate the kind of interests that might result in more risks associated with data sharing with the private sector. So I think that is one of the weaknesses in the current law. We will skip the next 2 slides because this is more about the blockchain and the AI, and go to the last one. So the current issues that I said, one is that the data is being looked into by government as a national security issue. So the national ID database plus the civil registration data sits in the Ministry of Homeland Security, whereas the Ministry of Information and Technology is the policy holder for the data protection bill. So currently there is this tussle which has resulted in this delay in terms of this current bill, which is sitting there in the Parliament, sitting actually in the Ministry of Justice right now. It has not even been moved to the Parliament. So this kind of the government thought process with some of these actors to look at data as a kind of a tool to control the citizens, or try to use the data towards their own ends, or towards in the garb of national security, is something that has to be addressed, because that is where now this bill is currently stuck. It is a good bill, though maybe a bit of a review to address some of the elements around AI and blockchain could be included. It doesn't need a very extensive kind of a review and revision. Some elements on the private sector, but I think it's a good progress. But it's currently this issues between the two institutions that is holding it back. So that's where we are. So we are doing the review of the National Registration Act, where the process is moving forward, but then it has the elements of data privacy and security have to link to the other bill, which is on the data protection side. So only a comprehensive bill can provide such kind of assurance in terms of integrity and confidentiality of the data. Thank you.
Thank you so much, Azahar, for the very comprehensive presentation and updates from Malawi. It is always a tricky one because technology develops really fast and then difficult to keep up. But I'm so glad that UNDP and the World Bank are jointly trying to strengthen the data protection work in Malawi. So now I'd like to move to Joanne. Joanne is, as I said, from UNDP Kenya. And as many of you may know already, Kenya's national ID project has some challenges due to data protection and privacy issue. And UNDP has been always there for the government to, support this process throughout. So Joanne shall introduce the support we provided for them. Joanne, we only have 10 minutes for you, so please keep time with it. Over to you. Thank you so much.
Yes, thank you very much, Lisa, and welcome everyone to this. Let's move on. Yes, thank you very much. this slide will highlight the importance of digitalization in Kenya. As a country, we have prioritized this. And with this, then in 2019, the Data Protection Act was enacted, which gave birth or established the Office of the Data Protection Commissioner. That is in 2020. And this office was mandated to ensure data security and privacy. So here I want to highlight some of the functions of the Data Protection Office, whereby it ensures effective implementation and enforcement of the Data Protection Act. It also oversees compliance of the Act and also handles complaints and investigation. Also, it promotes self-regulations by the actors in the sector and also evaluates compliance with the data protection requirements. And then the office also looks at public awareness and education and facilitates that. At the same time, it ensures that compliance with international convention and engagement is enhanced. The office also assesses the potential risks to individual privacy and carries out other prescribed functions and activities necessary for the effective implementation of the Act. Next. So yes, with the support from LIA, which benefited Kenya, Cameroon, and Zambia, we were able to support the government in strengthening the capacity of government to maintain a comprehensive civic registration. This process is ongoing in Kenya and it has taken off, but has not been concluded, so it's going on. So with this also, we helped the country through the UNDP support, we helped the country develop international or align the policies and laws to international norms and policies on civil registration and also look at vital statistics that inform the planning of the same. Next. Some of the challenges that were highlighted during implementation included the lack of integrated focus among the different government departments that deals on this subject matter. There was also outdated technology hindering digital transformation, and also the evolving legal frameworks for the data protection. Also, this was a challenge, and Kenya has many times, faced legal challenges in court, stopping this agenda. So that project, the area of focus for the project in Kenya really was to enhance coordination among the different stakeholders working on this sector, also to create awareness on legal identity in the country so that all the stakeholders are aware before the start of this journey. Also enhancing interoperability of the relevant systems that through digitalization. So we work with government to ensure that the different systems that are in Kenya now can speak to each other. And then finally, we also supported the development of different laws. Next. Now, one unique area we'd want to share experience with is the development of alternative dispute resolution framework for the data protection. And like I said before, the Data Protection Act in 2019 empowered the data commissioner to facilitate for mediation, negotiation on data subject disputes. So the government planned, to continue implementing the legal identity for all agenda, but it was faced by many hurdles. One of them is when the second phase was being implemented, there were court cases that came up to protect or to object to this agenda. And so this office, the Data Commissioner's Office, was put aside, also looked at having out-of-court settlement for the disputes that arose. So as UNDP, we supported it to ensure that this happens through different ways of ensuring that that office works optimally and that it has resources to ensure that the dispute resolution, alternate dispute resolution framework is implemented. Next. So why ADR? It was important because like I said, in Kenya, we encountered many complaints or many court cases that came up. So there was need to ensure that there's an out-of-court process of sorting out these disputes that came out. So the adoption of this ADR enhanced the complaint and dispute management, because now then, apart from going to court, then these cases would be sorted out of court. The government also was facing, like I said, many challenges, and there was a court case that was actually set to stop its work on legal identity or identity for all. And this also, the Data Commissioner's Office sought to seek, alternative dispute resolution to ensure that the agenda for legal identity for all is continued in Kenya. So there was need actually for this work to be continued, and hence the need for ADR framework to be implemented to deal with now the complaints and disputes that were coming up. Then there was also need for readiness of the office to facilitate out-of-court settlement where issues were raised, and the office was tasked to look for solutions. And there was need also to contribute to the efficient resolution for disputes arising in the context of legal identity work generally. So this office, UNDP worked closely to build its capacity, set it up, because it, like I said, it was set up in 2019. So UNDP was very critical in ensuring that the office is set up. They also in establishing mechanisms for facilitating now then the dispute resolution. So we worked together with the office, ensured capacity building for the people who are in this office to ensure that then their capacity is enhanced, and hence establish mechanism for facilitating alternative dispute resolution. Next. Okay, some of the key roles that data protection plays in the context of legal identity. This one is just highlighting the obvious that we've even come across as my other colleagues who are presenting their presentations. Some of the key roles is that there's need for privacy and confidentiality. There's also security and integrity, protecting the personal data from unauthorized access or damage. There's also consent and control, ensuring that we're giving individuals control over their data through informed consent, and then also accuracy and quality. We ensure that we are maintaining up-to-date and reliable information for accurate legal entities. And finally, accountability and governance. So we establish measures to compliance and provision of remedies for violations that happen in this area. And then finally, concluding, we see that it's essential and important to responsibly handle, personal data, and ensuring that security compliance is there and within the laws and regulations. We also acknowledge the importance of safeguarding individual privacy rights while establishing, and enabling efficient administration of legal identity systems. Therefore, integrating these data protection measures along legal identity initiatives is crucial to strike a balance between functionality and protecting individual fundamental rights. So we are working closely with government to ensure that this is mainstreamed as we take this journey in Kenya for, legal identity for all, and ensuring that we have identity management in Kenya. Yeah, thank you.
Thank you so much, Joanne, for the very concise presentation and updates from Kenya. I was in ID for Africa event at the end of May, and I still remember that President Ruto commended the data protection officer that she is tough and doing good work, because he can tell, because he receives complaints from other parts of the government that she is actually stopping some of the work. And that is the kind of way to tell that she's doing a good work. And it was really making me smile. John, do you want to add something?
No, thank you. I wanted to give you a thumbs up, but I can't seem to find where that is.
Okay, no worries. Thank you so much, Joanne, for a nice presentation. So
Yeah,
now I'd like to move to Pam from World Privacy Forum. She's a thought leader on data protection and privacy issues, and she was named as one of the most influential global experts in digital identity in 2021. So happy to have Pam today. So Pam, based on what you heard today, I'd love to have your views on how UN, in partnership with member states, can make our world a better place by protecting privacy and data. So Pam, floor is yours.
Oh, well, thank you so much. And it's a pleasure to be here. And I really appreciate the opportunity to respond to your wonderful report. Just a quick shout out to the folks who wrote this report in India. In 2016, I was at the center and gave a presentation, and I think I met some of you there. So I have a lot of respect for what the center in India is doing, and I really support their work. And I think that this is a really wonderful accomplishment. You know, it's always very difficult to make a comparative study of regions, but I also want to stress how important it is that this was done, because it would have been very easy to just revert to the GDPR because it's in so many countries, the General Data Protection Regulation. But they went beyond that and did an actual intellectual comparison. And I think that that is incredibly important, and it's work to be built upon. And also, I wanted to mention both Kenya and Malawi. I was, like Risa, I was in Kenya, in Nairobi in late May, and was able to both meet Immaculate Kasait, the Data Protection Authority of Kenya, and was extremely impressed with the work that she's doing. Kenya is in very good hands, and I feel very confident about where Kenya is going with their data protection with her. And I also was able to hear a little bit from Malawi in regards to their review, their overall review, and was very, very impressed with the progress that Malawi is making. So it's really wonderful to continue to see these really good updates. So I wanted to provide some responses to this gigantic report, very well executed report. I do have some feedback for you, just some gaps that I hope that going forward that you're able to include. So the very first thing I would say, just judging from the various jurisdictions that I've worked in, is that it's going to be critically important to include the private sector. Because as we know from the experience with Aadhaar in India and with ID in many other jurisdictions, there is a very thin membrane now between the government and, you know, the commercial sector, or the public and the private sector. And we need to be very, very careful of how ID systems are adjudicated in regards to the public and the private sector, and data protection in particular. For example, I live in the US, where we have a profound problem with data brokers. Data brokers are folks who are purchasing huge amounts of data, and they're selling them to both governments and the private sector, and it's just very, very messy. And before any of that gets started anywhere in the world, it's a really great idea to get that really brought under control, so it never sprouts up like a weed in your jurisdiction. So the only way to do that is to really look also at the private sector implications of data governance. So that being said, I wanted to just briefly talk about the notice and consent architecture. So notice and consent architecture is, there's something that, there's a very baseline privacy principle that came out early in the world called Fair Information Practice Principles. And these principles really do form the basis of most international law. Now, the various types of laws, such as the GDPR, as well as other kinds of laws, such as health privacy laws and financial privacy laws, have built upon this and added to it over time. But this notice and consent concept really grew from that. As the world has become more digitalized, the notice and consent proposal gets more and more difficult. We've really found this as digitalization has been increasing. So I would just, I think it's very important. We do need meaningful consent. I mean, if you think about health-based privacy and human subject research, you have to have meaningful consent. We can't do without consent. But at the same time, we have to be very cautious, because consent becomes more and more difficult when you're in a real-time, fully digitalized environment. So that's something to really take into consideration. And I know that this report did, but I just want to highlight it as well. We have very limited time, so I'm just kind of brushing over some highlights. I agree with the report. The decentralization of identity is, on a technical basis, profoundly important. It's an incredible infrastructure that's being built across many jurisdictions. And I think it's very, very important. And in terms of how ID works with privacy principles, decentralization really helps with a lot of problems that can crop up in various identity ecosystems. But there are three things I wanted to bring out that weren't necessarily completely covered in the report. So the first one is this. So it has become very popular for governments to talk about selling their identity data within their ID ecosystems as a way to finance the identity authority or the ministry holding the data. We need to be very cautious with this. So it is true that some governments do sell data, but they're selling it under very, very constrained conditions, and the sale of the data is only to cover costs. It is not to make a financial empire or to create funding for the identity ecosystem. The problem with this is that it can really lead to a lack of trust of the people holding the identity cards or the identity numbers, or however your system is built. So this is a really significant red flag that needs a lot of data protection and governance, and it should be discussed very early in the process of setting up an ID. It's how you're going to handle data sharing within the government. And then if data sharing is ever to be allowed outside of the government, what are the legal controls? The legal controls of choice, of course, would be some form of legal jurisprudence or legal requirements, such as a warrant for the release of identity information. The identity ecosystem really needs to be trusted, and having very firm processes in place for access to the identity data by all parties is just essential. The next item is the use of mass DNA collection within ID ecosystems. I do think we need to draw a very bright line here and understand that this also is something that creates a very significant trust problem. And I know that this issue is coming up more and more, but we need to be very, very cautious. I do think that, for example, iris is one of my favorite biometrics due to its accuracy and its lack of bias relative to other biometrics. That's fine. And I think we all understand the need for disambiguation in the use of biometrics, but the mass collection of DNA just to sit across all the population in an identity ecosystem is very dangerous, and we must be very cautious of that. And then I just want to provide a concluding thought, and I would actually encourage the report authors to write or consider writing an addendum to be published in, maybe a year or maybe half a year, which is in regards to various forms of artificial intelligence. So we all know about AI and machine learning. There is very classical forms of artificial intelligence, such as credit scoring, Credit scoring has been around since the 1950s. There are even older forms than that. It's been regulated since the 1970s. So machine learning is not at all new. However, this year in February, a newer type of artificial intelligence called generative artificial intelligence. This is what people have been hearing about in the news with, for example, one company is called OpenAI, and they have a product called ChatGPT. This is just one of many such products. But I bring it up because generative forms of AI function in a very, very different way than classical predictive AI. So language in existing data protection legislation that talks about prediction, it doesn't actually apply because these are not predictive systems. They're generative. They operate in a non-predictive manner. And we need to find different ways of crafting data protection legislation to address the problems that these newer systems that have finally reached maturity propose. So for example, in generative AI systems, the systems can lie to us just outright. It's called hallucinations. That's the technical term for it. But if a system lies to you, and for example, maybe lies about a person's identity, it can create novel forms of identity fraud. So we're going to need to consider this and develop new regulations. We are all at the very beginning of this. So in general, though, I am very, very pleased with the UN report. I would just really encourage coverage of the private sector because it's so important, and then attention to some of these other issues. But my congratulations to the authors for this really wonderful and very comprehensive work across regions. It's a joy to see a detailed work like this that is truly multi-regional. I've been waiting for this for a long time, and I think it's a very important document. Thank you very much.
Thank you so much, Pam, and very well noted. And I cannot really agree more on the importance of the private sector engagement and, against mass collection, the DNA samples, and very need to be careful on the selling ID, especially when government collects them. And also to do more on generative AI, which is upcoming. I mean, it's already here. So we really need to do something. And I am more than happy to continue our discussion to do addendum of this report together with colleagues over here. So thank you so much, Pam. I'd like to introduce my colleague, Niall. He used to be working with me on legal identity at UNGP. Very sadly, he left us, but this is the initiative that he originally started, and I want him to say a few words on the importance of this work and then his thought on it. So now over to you, very briefly though.
Yes, Risa, thanks a lot. I won't take up too much time. I again just want to thank Jalak and Aishwarya and all the people at the CCG that worked on this. It was an immense project, as we are all aware, and I'm very, very encouraged and enthused by Pam's comments there in the end as well. I've always felt that the UN, not just in UNDP, but across other agencies perhaps as well, that work on other forms of support to civil registration or identity management or whatever, that we've quite possibly just neglected the whole area of data protection and privacy in the design and support that we've offered to member states over the years. And this publication really came about from a desire to try to put that straight. This publication is also in many ways almost like a sister publication, even though it's far more comprehensive, but a sister publication to an earlier one we did that documented all of the UN's internal data protection and privacy policies. That was published in 2021. We looked at all of the what we would call normative resolutions and texts of the UN with regards to data protection and privacy, i.e. that would be documents approved or resolutions passed by the UN Human Rights Council, by the General Assembly, reports of the High Commissioner on Human Rights, etc., that have the weight of international standards or have the weight of the UN's position on particular things. But we also looked at other internal policies that the various agencies such as UNHCR or the World Food Programme or UNICEF or UNDP or whatever, what internal policies govern their own processing of personal data. And so both of these publications together, I really do think help give the UN a leg up along the path to assisting country teams, support governments wherever we are requested. And indeed, as Pam has mentioned and other speakers have mentioned as well, you know, as more and more of our lives are lived online, the issue about how data related to us, our personal data, is handled simply becomes more important. This is just inevitable. We don't know what's going to happen with regards to developments in the metaverse or a metaverse or some form of multiverse or whatever in the coming years, but we can be absolutely sure that more and more things will be determined and governed and documented via digital online identities, as opposed to formerly plastic paper credentials affirming state-issued identities. This is just inevitable. It's a fact of life, and we have to be prepared to support it. And then the last thing I would say with regards to one aspect of the report in particular, I think we're quite proud of, is the focus on the institutional governance and the structuring of data protection authorities or information ombudspersons or whatever. Realistically, this is probably an area where UN country teams are likely to be requested to assist where possible. We may well end up assisting in the drafting or the revision of data protection privacy laws, but I think just as in other areas, like with regards to election support, for example, a lot of our work over the years has focused on capacity building of electoral commissions. I think capacity building and institutional strengthening and institutional design of data protection authorities, privacy commissioners, information ombudspersons, etc., that's likely to be a large part of our work. And therefore, we were thrilled when CCG, Jalak and Aishwarya, etc., wanted to have a chapter speaking about institutional governance and comparing the institutional governance across the various regional frameworks that they did look at. We didn't, by the way, and this is my very last point, we were absolutely adamant and determined when we were putting this report together that we don't just focus on some of the more, let's admit it, high profile data protection instruments, such as the European Union's GDPR. We wanted a global reach, and we wanted to do a comparative study that looked at how the African Union does things, Association of Southeast Asian Nations, how the Caribbean community does it, Organization of American States, etc., and put it all together and show the common themes and trends. So that's why we're particularly proud of the document. Congrats once more to Jalak, Aishwarya and the team in CCG, and to all of the other panelists here today. Thanks, Risa.
Thank you so much. Now it's always nice to have you speak. So thank you so much for panelists and everyone here who attended this session. I hope this gave you ideas of what we can do and what we should do to ensure privacy and data protection, especially when we have legal identity project. So as I mentioned, this webinar series is on a monthly basis, and we are planning to focus on methodology of calculating the number of the people with a legal identity in subnational level in the next webinar. So I hope to see you there too. So with that, I would like to conclude this webinar, and then thank you again so much for participating, and looking forward to seeing you next month. So thank you so much.